Good evening, and my name is Lawrence Berliner. I'm an attorney in the field of special education law. This evening we have Jane Faherty, who's the director of the Stamford Jewish Community Center JumpStart program, and a special guest, Allene Grafman, who's an educational consultant advocate. And we're going to have a roundtable discussion. We are continuing to present these webinars because we are part of a community of concerned parents and professionals, and we're all still learning how to connect in order to get through these difficult times created by the COVID-19 health emergency. The good news, I think we may be seeing a very light at the end of the tunnel, and certainly there are changes on the horizon for the next school year. All of those changes are still fluid and work in process, so we'll discuss what's interim at this point in time. Throughout the school year, we've been moderating a series of webinars on a variety of topics to help parents and students and others who are involved with the field of special education, involving physical distancing, virtual learning, in-person learning, hybrid learning, and the impact that this sea change has had on our child's lives and their parents' lives, and certainly the educators' lives as we are getting through this COVID-19 health emergency. We've convened again tonight to address some questions and concerns. We received several questions in advance of the webinar. We ask that your webinar, excuse me, I misspoke. We ask that your questions be general in nature and that you use the Q&A function that's at the bottom of your computer screen, not the chat and not raising your hand, which is one of the features. This webinar is being recorded. The information provided during the webinar does not constitute specific legal advice to you and or your child's circumstances and should not be relied upon as such. The webinar does not establish an attorney-client relationship with Attorney Berliner, myself, Allene Grafman, an educational consultant and advocate, nor Jane Faherty from the Stamford Jewish Community Center. By signing up, you've agreed to receive information about future webinars and events from the Stamford Jewish Community Center and the Law Office of Lawrence Berliner. This webinar is being recorded on Zoom. Zoom is a third-party provider and not an agent or associated with the Law Office of Lawrence Berliner or the Stamford Jewish Community Center or Allene Grafman. Without further ado, I would like to get into the topics. Tonight's webinar is sort of a continuation of our last webinar, where we were talking about annual reviews, end of the year meetings, and how to sum up the 2021 school year and move forward into the 21-22 school year. We had a lot of questions left over, a lot of concerns, a lot of anxiety with parents and others. So we're going to go over some basic educational rights, some interim guidance from the State Department of Education on the continuation or lack of continuation of remote learning, parent input, concerns regarding the child's progress, some pragmatic skills, and certainly anxiety that all people have been dealing with this past 18 months. Looking ahead for the new school year and next steps for your child. We are fortunate. Jane Faherty will introduce herself, but I'll give a brief biographical outline for Allene or Allene Grafman, who I've known for many, many years, helping children with special education needs. She has a master's degree in special education and a 6-year in school administration. She taught children in special education in public schools, and that's actually how I got to know Allene as a teacher and an administrator. Fortunately, she retired and came to our side as an advocate for children with special needs. And she has used her experience as an educator in that field to be an effective advocate in this field of advocacy for children with special needs and their families to ensure they have a free, appropriate public education. Without further ado, I will turn this over to Jane Faherty, and she can discuss herself and her background, the JumpStart program.
Hi, it's nice to see you all this evening. So my name is Jane. I have a master's degree in early childhood education with special needs. I'm also a parent. I have 4 children, currently sophomore, junior, senior, and first year at university. And my main focus has been early childhood. So I work in the Stamford JCC, and I'm the director of a program called JumpStart. The JumpStart program primarily works with children just before their 2nd birthday, and then I help them transition into the public school if they're eligible for support and services on and around their 3rd birthday. I also then continue to advocate and support the children and their families as they continue through the public school system. And as I've been doing this for a number of years, a lot of my children are now transitioning into 4th grade, some even 5th grade, and I have some middle schoolers that I help as well. At the Stamford JCC, we run a number of different programs, not only for those younger than 3, but we also do young adult programming during the week and at weekends. And we have a summer camp program called Hand in Hand, which is for children aged 3 through to 8th or 9th grade. And if you go to a Facebook page called Jump Stars, you'll see we have a collaboration with STAR, and we provide educational, such as this webinar, social and recreational activities for parents and caregivers. So if you check out our Facebook page, coming up, we have an evening of kayaking, or we have a sunset sail on a schooner. And all of these activities are at no expense to the parents. So it's a nice way to connect and come together, which has been very difficult for everybody these past 12 months. And as we all know, if you don't take care of yourself as parents, it's really then hard to take care of the needs of our loved ones. So I do encourage you to start thinking about yourselves and how you can be supported and part of a larger community. But it's a pleasure tonight to have Ali here with us. I met Ali last night, and I love the fact that she has experienced both as an educator, administrator, and now as an advocate. So she really has a nice rounded experience in which to support you as parents and your children. So thank you for joining us tonight, Ali.
And before we begin, I have one housekeeping note. If you go to the chat section, you'll see all of our contact information. Mine, Ali, and Jane's are there, so you'll be able to contact us if necessary after the webinar. The other housekeeping note I have, there is some pending legislation in the Congress that involves the issue of the use of seclusion and restraints in public school setting. And we're very fortunate to have Senator Chris Murphy, who's on the HELP committee, that stands for Health, Education, Labor, and Pension, taking the lead on a law that's called CASA, K-A-S-S-A, Keeping All Students Safe Act. If you are in opposition to the use of seclusion and restraints in a public school setting, I would strongly urge anybody who cares about this issue to please contact Senator Chris Murphy. He has a website, an email. He really appreciates this kind of input. If you want to write any other elected official, like your United States representative or Senator Blumenthal, please do so. But this is legislation that was introduced a couple of years ago by Senator Murphy, and it's now coming to a head in the US Congress. The other piece that I wanted to mention, this just came to my attention the other day. We have in the Department of Social Services, a state agency, what are called Medicaid waivers for young adults with autism. Connecticut is eligible to add 50 slots this coming fiscal year, which starts on July 1st. And it's very, very important that you contact Governor Lamont's office. Governor Lamont's can be found at ct.gov, the state website. And there's a drop-down menu. I use developmental services on the menu to let Governor Lamont know that these additional slots are vitally important for young people with autism. This is on the Medicaid waiver program. And what it requires is that the state of Connecticut make an allocation, an appropriation to the Department of Social Services, and the rest will be picked up by the federal Medicaid program. So if you are deeply concerned about expanding the pool of slots for Medicaid waivers for people with autism, I urge you to contact Governor Lamont's office. And the last piece actually dovetails with what Jane does for her work, and that is Governor Lamont issued an executive order the other day extending the birth to 3 eligibility period. Are you familiar with that, Jane? Maybe you want to handle that.
Yeah, it's been interesting. So what's happened is that the state has allowed the birth to 3 agencies to continue to work on with the children past their 3rd birthday. Technically, upon a child's 3rd birthday, if a child was eligible for support and services, it would then become the responsibility of the school district. But because of COVID, they have allowed those services to continue to extend. However, it's so new at this point. I have spoken to different birth to 3 agencies and different districts, and they're still trying to figure out how that's actually going to work and the practicalities of that. What I do know is that some districts may be taking advantage of that. And if your child is turning 3 just before the end of the school year, rather than encouraging, should we say, the child to take up the classroom position, they are suggesting that it might be more viable at that point to continue with birth to 3 and then maybe join them for the beginning of the ESY. So you might be talking about a 2-3 week period, for example. But every district has been handling that situation slightly differently, as have the agencies. But it is of a benefit because as a parent, when you've been working with the agencies, a lot of my families have worked with birth to 3 agencies since their child maybe is 3 months old or 6 months old. It is nice and reassuring for them to continue to have that relationship with the specialist, whether it's the PT, the OT, the teacher, the behavior specialist, speech pathologist. So it is of benefit to the families, but the districts are also seeing this as an opportunity as well.
Now, without further ado, our special guest, Allene Grafman, if you want to give a little background above and beyond what Jane and I have provided, and tell us what's going on in your experience as an advocate this year, especially as we are coming to the close of the school year.
Well, first of all, thank you for inviting me to be here. It's really a delight, and I'm so happy that we have participants from all walks of life to join us. So it's really exciting. As Attorney Berliner did say, that I come from a public school background. I've been in special education all my adult life. On a personal level, I have 2 grown kids and grandchildren who, by the way, have IEPs. So here I am again. I'm wearing 2 hats a lot of the times. But as Attorney Berliner did say, I come to advocacy after retirement, looking at advocacy as a way to continue my work with families that I started years before, but in a different perspective. We understand that navigating public school is not an easy pathway. There are many bumps in the road, pathways to follow, and Parents, they are not expected to understand how to navigate that. So coming from that public school background, it's never easy, and I'm always learning as well. But I do have that experience behind me to guide the families into the most appropriate pathway for your child. So I enjoy what I do. I really do love the work, and it gives me such pleasure to see my clients and their children benefit. My motto is, for me, I want to see the parents that I work with to become their own best advocate for their children. My goal is to leave after coaching and guiding families so you can become the best advocate. And that is truly what I believe and hope to accomplish. So again, thank you for allowing me to be here tonight.
I agree with you, Ali. And quite often families get into a situation where there might be a breakdown in communication, or and you have to help those families build back that relationship and build back those effective channels of communication, and to really share how they would like to receive information, the timely manner within which they'd like to receive it, and also the medium within which they'd like to receive it. And particularly when my families are starting and transitioning into the public school, to me, that's one of the most important pieces, is helping the parents establish an effective relationship with the district and establishing the guidelines with the district on how they would like to be communicated and the frequency of that communication, and to hold the district accountable and responsible for that as well. What do you think, Ali, in your experiences?
Well, what I'd like to see and encourage my families to do is not to burn bridges and to always promote collaboration and communication. Many the families I work with have more than one child in the district, in the system. So you're not going to, even if you're, the child that we're working with is in high school, you may have somebody younger, and you've got a long ways to go with that district. Effective communication is the key. Even when I was in public school administration and I sat at PPTs in team meetings as such, communication, that's what parents want, that's what they deserve, and that's what they should strive for. So to build those bridges, I always encourage parents to begin with the people that work with your child. If it's the teacher or the social worker, whoever you're communicating with that you may feel that you have a problem, begin with that person. And then from there, you go step by step, and you need to go possibly higher up. You need to work with advocates or outside resources. But the first step, in my opinion, is to work through that collaboration process and build those trusting relationships, which will take you a long way.
And I might add, collaboration is a door that swings in both directions, not just one direction. And it's very important that the parents not only understand what is going on with their child, but understand sometimes we're talking in a technical jargon or acronyms. And it's very important that the parents understand what the school reports are saying, what the school staff are saying, and they have a full, better or complete understanding. I tell a story many years ago. I had a client that called me up in a panic because they wanted to give her son a rat. And it was around Thanksgiving time, and it was the class pet, which happened to be a rat, and she didn't want a rat coming home. But what the school was saying was it was a WART, which is a wide range achievement test, and not a rodent. And a simple explanation would have avoided this panic phone call to me. And it's a true story, and I use that as a very simple example to make sure you're on the same page, understand the acronyms, understand the lingo, understand the educational implications of a high test score, a low test score, and most important, what you see as parents, because parents are a very important source of information. in crafting an IEP, one of the very first things, if not the first thing in the federal regulation, is taking into account the concerns and input of the parents. Not talking about the teachers, not talking about the evaluation report, but starting with what the parents' concerns are.
Ali and Lawrence, one of the challenges I have observed this year when at PPT meetings and advocating for students is the gathering of data. The information that the school districts have provided has not necessarily been as robust because the children have been in hybrid and teachers might not have had the same opportunities to do evaluations or assessments. However, the parents have been in the position at times to provide information and data to the school districts. How have you, Ali or Lawrence, or both of you, found that at this stage, when we've come to the end of the academic year, we are reviewing a progress that a child has or has not made to date? How have you found sharing that data that the parents have collected? How have you found that's been received by districts? And do you have any tips or insights for parents on how to have greater understanding on how to monitor and track their child's progress, rather than just taking for granted that because a district says they've mastered something, that they actually have mastered it?
Attorney Berliner, do you want me to start, or would you like
Absolutely.
to? Okay. That's a loaded question, Jane.
Mm-hmm.
and it has been a very interesting year with parent involvement, because up until this year, I found sitting at PPTs, and a parent would say, oh, well, my child is not behaving that way at home, or I don't see my child's progress as such, because when he or she does her homework, she can't understand it, and the school is saying something completely opposite or completely different. Oh, they're saying, oh, well, we see a whole different child, they're on track, they're making terrific progress, whatever. This is the first year that parents are given the, I guess, the magic wand, the tools to say, my progress tracking, my monitoring makes a difference, because I was the one, or we were the ones that were monitoring the progress at home. The teachers didn't see it. So their data collection was extremely helpful and important and significant this year. When I worked with families this year, I gave them charts to follow. I gave them data collection procedures, and data is good, but qualitative, or I should say quantitative data is probably the most important, because you can't argue with that. It's quantitative and it is very specific. But narrative data is also, helpful. And that has to be recognized by the school team, especially this year. So when we go forward now into this end of the school year, the parents should continue presenting that data and see if it corresponds with the school's data. We have IEPs that are certainly not the most user-friendly, but as you know, the goals and objectives are assessed every either quarter or trimester. You get that goal reporting sheet. I encourage parents to ask the staff, the team of people that are working with your child, to show me the data. It's like, show me the goods, okay? However it is assessed, if they're saying that it's assessed through baseline performance compared to end of the year performance, show it to me. I want to see it. And that really is a true assessment of progress. So, a kind of a tip, and Jane, you asked for tips. Well, one of the tips would be to inform the PPT prior to your meeting that you will be asking for those data points, and you want them presented either, I encourage families to have the school give it to you before the PPT, so you can naturally review it before. But you want to inform them so they can't at the PPT say, oh, well, we don't have it, but we'll send it to you, and then you probably don't ever get it. So You know, that's a tip, and I found that very effective because that's a way to follow through and hold the school accountable.
Mhm.
Larry?
Just, I have nothing to add. I mean, I agree with everything you say. I don't have anything to add on the process, but again, the progress monitoring, as you point out, is happening at home, especially when children are on hybrid or remote learning. And I think it's an important source of information. I would add that if you look at the IEP goals, the goal page, in the middle of the page, there isn't a section on how the goals will be evaluated. Yes, they're going to give you quarterly or trimester reports, however often report cards are issued, but where's the data? So if you look at the evaluation procedures, you'll see a number or a letter, and you go down to the bottom of the page, and you might see, baseline, post-baseline, however they're evaluating the student's progress on the IEP. And you should request that data because it exists. The only one that doesn't exist, and I don't like this, is teacher observation, because there's no way to measure teacher observation. But if there's baseline data, other data, assessments, you should be able to read along with the school and say, yes, my son or daughter is making that progress or not. The other piece I would point out is whatever a child learns in school should be generalized.
Mhm.
We're not putting children in school to be students in school for the rest of their life. We're putting students in school to be students of life after they complete their formal education, whether that's after high school, community college, graduate school. And we're working on building those basic foundational skills, academic skills, emotional skills, social skills, whatever skills we need to be successful, especially in this complex world that we live in, that we will have capable, successful citizens when they are ready to take their rightful place in our society.
I would also, I had a PPT the other week, and I got a copy of the progress report, and a school district suggested that a child had mastered a skill when they'd only achieved 70% mastery based upon whatever their data points were. And I think it's important. Expectation is critical for our children and for all children. And it's very important that 70%, if that were a typical child, would just be a grade C equivalent, for example. As a parent, is that mastery if you just get a grade C, or is that just kind of average? So don't be afraid to challenge and question and make sure that the school's expectation is as high and the same as your expectation of what mastery is, and challenge if you don't see that your child has mastered something at home. Bring that information, whether it's video, whether it's multiple videos, because mastery would be consistency over time. And if you have multiple videos to show that a child hasn't mastered a particular skill over time, you can use that to support your argument that maybe they have a lower expectation of what you would consider mastery, and that can also help drive and develop the IEP goals to make them more appropriate for your child. But what do you think, Ali and Larry, on that piece of expectation being critical for an IEP too?
Well, I would just paraphrase the United States Supreme Court's decision in Andrew F. That was issued in 2017, where the justices of the Supreme Court stated we should have robust and ambitious goals and objectives. So dumbing down a curriculum, dumbing down goals, 70%, if 70% is acceptable for students with disabilities, would 70% be acceptable for students without disabilities? So that way it's parity. And I don't think it's acceptable for students with or without disabilities. The other thing I would say is it also depends. I have actually seen IEP goals. I haven't seen them in a while, but I can pull them out because I've saved some of the interesting IEP goals. And this one involved a student who was visually impaired, who had travel training, and the objective was to use a crosswalk with 80% accuracy. Now, what's supposed to happen with the other 20%?
The other 20%.
Yes, and that's a real story, but it illustrates the point. It illustrates the point. That's an extreme example, but it illustrates the point. We should have the same expectations, the same goals and outcome. We shouldn't artificially hold back children with disabilities because they have an IEP. And that's what the Supreme Court talked about with robust and ambitious goals and objectives.
I would just add one more thing to that. I think that parents and guardians also need to really look at the goals and objectives and always ask what your child's baseline performance is. It's so important to know where they're starting from, because if the IEP objective says mastery is at 80%, you don't really know if your child is starting at 20%, 50%, 75%. If it's 75%, mastery at 80% is no big deal. I mean, it should be then brought up to 100% or whatever. So I think, and I don't think that parents are necessarily vigilant about that, because you're concentrating on the way the objective is written, but you also have to know where your child is starting from. And progress is only measured by such indicators, where he starts or she starts to where they're ending. And I think that's another thing that we really have to be vigilant about.
So this relates to a question that we were just asked, actually, following on from data. So what specific data should somebody request prior to an IEP meeting?
Jane, can you repeat
the question? The question was, what specific data should a parent request prior to an IEP meeting?
Well, that also depends upon the specific goals and objectives that are outlined on the IEP. And so again, the specific information you would want is what evaluations, informal or formal, standardized or performance-based, what evaluations they are using to document progress. That's one point of information. Another informative piece of information would be to make sure that your child was seen by the service provider. So you may want to ask for an attendance record of the visits and the length of time of service delivery. So that's another thing that we sometimes don't even think about. And then lastly, and there's probably many other indicators that you want, but you really want to ask for the teacher's structured observations. A lot of times the teachers love to talk. I know I was one of them, and they always usually try to say something very positive. And also their narratives are usually pretty strong. They go into, how great your child is doing and all that. But a structured observation is different. A structured observation is with target indicators. So if you have a child that's ADHD and has attention problems, the structured observation should be about how long did your child sustain his attention during X amount of time and during what class periods, throughout the day. So there's other indicators. If your child has difficulty with impulse control and calling out, those are things that a structured observation should be able to keep data on and also report back to you. So again, it's very IEP specific, but you want to get as much accurate, again, quantitative data rather than narratives. Narratives make us feel good because, as we talked about, and we're mostly very positive. But a PPT meeting should really be about targeted on your child's needs. We all know how great your child is and how respectful, and we want to hear that, but a productive PPT is about specific progress being made.
I would just add to that two things. Work samples, yours or the schools. I was at a PPT the other day, and the school said we have no concerns with the child's handwriting, and the parent introduced a note that the student did at home, and the word was A-N-D. I didn't know what the word was because the A looked like a U, the N looked like a W, and I have absolutely no idea what the last letter was in the English language. The other thing I would also remind parents is under the current Adapt, Advance, Achieve Connecticut's plan to learn and grow together, which is affectionately referred to as the 2021 school year reopening plan. In appendix number 6, footnote number 1, the school districts are supposed to provide all their data that's going to be reviewed at a PPT meeting at least 3 days before the meeting. So you have it in advance to ensure your meaningful participation.
So Larry, one of the questions that we were asked prior to today's conversation is what steps to take when the district has violated your child's IEP?
Well, that's a very broad question, but often that's how Allie, or more specifically myself, get involved with these cases. For me, it's what are the parents' concerns? How is the violation occurring? Is it the IEP as written not being delivered, which certainly happened last year? We had school closures, we had COVID-19 health emergency, reformatting the provision of all public education, special ed and regular education. So I listen to the parents and look at the IEP. Are we dealing with the IEP as written not being delivered, or the IEP is delivered as written, but there's a denial of a free appropriate public education, namely they're not making the progress that's reported by the school. So sometimes there's no one fixed answer, but sometimes we need outside evaluation reports, outside observations, and if an objective set of eyes and ears can see the same thing that the school is saying, then maybe there's not a violation. But if that same set of eyes and ears is seeing what the parents are seeing or saying, then maybe there is a violation. Parents have their procedural safeguards, which I might add, there was a brand new set of procedural safeguards issued at the end of March, so make sure you have the most current version, which is about 30 pages. It's not in all the legalese language in the old procedural safeguards. Is a lot more user-friendly. And those are your rights. Those are your substantive rights to a free, appropriate public education. Those are the child's procedural rights, which include requesting a publicly funded independent evaluation, going to a due process hearing, filing a complaint with the State Department of Education. That's an informal complaint. The formal complaint is a due process hearing. And there are other remedies that are available. But for me, it's very important that we understand how, when, and why the IEP is being violated, because we don't want to act precipitously and file for a due process hearing when we're not ready to go to a due process hearing. We don't want to automatically request an independent evaluation and then have the school district file for a due process hearing. And to go back to what Allie said, communication, that's very important. So let's try to get on the same page. Maybe we can have an informal meeting, a telephone call, a Zoom meeting, an in-person meeting, and try to understand where the proverbial wheels went off the track before launching a request for an independent evaluation, or filing an informal CRP complaint, or filing a request for a due process hearing. But of everything, you have your procedural safeguards.
Thank you, Larry. That was very comprehensive response. And as an advocate, I'm not quite at the same, I don't work in the exact same way because I'm not an attorney. I support clients. So I don't go into due process and certainly don't advise clients at certain points to go to due process unless that's the last resort. And usually when they go to due process, it is the last resort. But for me, in working with families, it depends how much in violation the IEP is in regards to the impact on your child's learning and education. If it's very significant and detrimental to your child, then absolutely, you probably would want to get, either an advocate, an attorney to follow through and usurp your parental safeguards and look at either an outcome that is very different and much more effective than the IEP that you currently have. If you feel that you've already are up to here with the school and you've gone through many, many steps and the school has not responded positively to you, then your due process rights probably need to be invoked. So it really depends what step you are on the way and what outcome you want to see happen.
So one specific question related to what we've just been talking about, to be more specific, is somebody's asked that IEP goals would change without their consent or knowledge. What steps should that family take next?
Well, there's two separate questions that have been conflated. Connecticut is not a consent state where the parents consent to an IEP. Some states are, we're not. But without their knowledge, that's a different question, because a change to an IEP can only take place during a PPT meeting with the parents' participation. And if there's a disagreement, then the parents have their rights, the procedural rights, to challenge the IEP. So an IEP should never be changed without the parents' knowledge. And if it is, there is an informal complaint process called the CRP, which stands for Complaint Resolution Procedure, which is an informal request for an investigation by the State Department of Education if the IDEA, which is the Federal Special Education Law, is being violated. And that is one of the violations that a parent could allege. And speaking of the CRP, and one of the questions that was posted, where can people find this information? Well, a lot of information that I'm talking about, like the CRP procedures, and somebody had asked, where do I find the new procedural safeguards, are all available on the State Department of Education website. ct.gov is the state website. It'll open up to departments and agencies. You click on letter E for the E agencies like Department of Education. And then you will see a section entitled Special Education. You click on that, and it's a little obtuse, but you can navigate that. Often you're looking for a list of publications like CRP complaint procedures. It's a little booklet, about 5-10 pages. Type in procedural safeguards, and the edition you're looking for is dated March 2021, not 2006 or 2010, I think, were the last two revisions. And it's a user-friendly booklet. And if you don't find it, there's nothing preventing you from calling the Bureau of Special Education, whose department numbers and the personnel are also on ct.gov as well. And so call them, send them an email. I'm sure they'll help you. They have what are called educational consultants who are readily available for the public to find this information, or they'll send it to you.
So one of the biggest concerns this year, and that has been noted by parents as well as educators alike, is regression. So one of the questions that was posed to us, Ali, before tonight was, What if the child's regression is the district's fault due to failure to provide services, related services?
Well, first of all, regression has to be addressed, and services have to be in line with the student's needs. So the first step is to go back to a PPT, and you would want to know what measures of regression do we have? Because there are many ways to assess a child, right? So, you know, if you're saying, the parents are saying my child has regressed, the school may be saying something differently. So you have to come to a common understanding. Is the child really regressing, and what, you know, what assessments or what indicators do you have to show regression? If you are both on the same page with that, the family and the school, then my suggestion would be to further evaluate the student to make sure that the IEP is appropriate. By that I mean that it's very possible that the goals and objectives that were originally developed for your child may not be aligning or matching your child's needs. So either a school, an in-house evaluation, or if you feel that you want to go through a private evaluation, or if you disagree with the school's evaluation, you can ask for an independent educational evaluation at the district's expense. But certainly an evaluation is probably warranted to really define what your child needs, and then go back to a PPT to revise those goals and objectives.
We had one question, and Jane, I don't know if you have a different answer. How long has that birth to 3 executive order been extended? And I'm looking at the executive order, and the expiration date is July 20th, 2021, unless earlier modified or terminated. Do you have any other?
No, that's the only date that I've seen to date as well, is July 20th of this year.
Okay. And then there was another question. Let's see. Are there documents to ask for 100% remote learning? There is an IEP implementation plan, which basically tells the parent how an IEP will be implemented with virtual hybrid learning. So the IEP itself hasn't been changed, but how it's going to be delivered has been changed. And that's what the IEP learning plan is. The problem is, if you look at the interim guidance for remote learning that was issued at the end of April, there may be more coming down the road, but as of April 27th, the State Department of Education would like to do away with the mandate of remote learning for the 21-22 school year. Quote, at this time, the Department of Public Health and the Department of Education do not anticipate the need to mandate, due to public health necessity, that all school districts provide an option for students and their families to opt in to voluntary remote learning after this school year. I personally think it should be an option for parents, but I'm not in the policymaking business. I'm an attorney and an advocate, legal advocate for my clients. But if you have concerns, contact the State Department of Education. So since this school year is almost over, you know, the remote learning option as a mandate is going away, and it's really up to the local districts to continue that or not continue that. I don't know if Jane or Allie have received any information. I know of one school district that's doing away with it.
Not additional information on that, no. But I do want to go back, Jane, to the regression and that question, because I didn't get to the part where it's if it's indicated that the child didn't receive services, which is what the question was asking, what are the next steps, or what do you do? And you know, I think that's a very legitimate question, because you as parents have rights. If in going back to a PPT, if you can evidence the fact that the child did not receive services or did not receive adequate services, there are different options for you. You can certainly ask for the services to continue. You can ask for services to escalate, in other words, more services within the school day, or you may even opt for compensatory services, which is another whole nother situation. But you may be entitled to compensatory services due to the failure of services being provided. So aside from the IEP and making sure that the goals and objectives are aligned to the child's needs, which can make a difference in regression, you also have the right to request evidence of services and make sure that services either continue or increase in the amount of time that your child is being serviced.
Yeah, one of the advantages for some of my clients during this period of remote learning is they could actually see the number of minutes that a related service was provided virtually. And whereas the IEP might state it would be 1 times 30 a week or whatever the denotion may be, the reality was that the parents would see that maybe the related service was only being provided for 10 or 12 minutes. So they kept a record and they've added up the number of minutes that their child did not receive and are now having those related services offered at different times during the year in order to compensate for the lost specific related service that the child should have received earlier on in the school year.
That's one of the reasons when I stated before about tips for what to ask for at a PPT, I mentioned attendance in the service provider hours, not just special ed teacher, but related services, which means speech and pathologists, OT, PT, social work, whatever. It's not a practice that you have to ask for every single one, but certainly ones that, certainly areas that you may have some concerns in. So it's a good idea.
We had a question, can a school district deny a parent's right to have an independent evaluation at the school district expense? The answer is yes. When a parent requests a publicly funded independent evaluation, the school district has 2 choices. They can say yes or no. If they say yes, they'll pay for the evaluation, provided the evaluation meets the criteria for outside or independent evaluations. If the school district says no to the parent's request, they have to file for a due process hearing within a reasonable period of time to defend their evaluation. Now, there is an independent educational evaluation policy guidance booklet available on the State Department of Education website, ct.gov, that goes into greater detail than what I'm stating. And one of the items you'll see is the school can take up to 10 days from a PPT meeting to make a decision. So that's one decision that may be made at a PPT meeting, granted or denied, or it may be a decision made up to 10 days following the PPT meeting. It's always advisable to understand the school district's obligations to either grant or more specifically deny, because a lot of parents don't understand after their denial by the school district why they're getting paperwork from the State Department of Education scheduling a due process hearing. I don't have the page number on the March 21st guidance, but under, I'm sorry, the procedural safeguards, but under the old set of procedural safeguards, it was on page 7. The independent educational guidance is a separate publication, and parents should consult both their procedural safeguards and understand what their rights are, and the policy guidance to understand in greater detail what's involved with a independent evaluation request.
Along a similar vein, a question was posed before today's webinar that said, I already filed a complaint with the State Department of Education. What is next?
Well, it's a good question, but it depends on what kind of complaint. I had mentioned earlier that there's this informal complaint called a CRP, Complaint Resolution Procedure Complaint, that's filed with the State Department of Education. It's not a request for a due process hearing. It's an investigation, often a paper review. You know, the school district will send documents to the State Department of Education. The family will send documents to the State Department of Education, answering some questions, sometimes in an email or a phone call if there's some misunderstanding. Prior to the COVID-19 health emergency, the state had to investigate that complaint by taking up to 60 days to investigate and issue a decision. The state has requested extensions of that 60-day timeline because of the health emergency. If we all get back to full-time, being in our offices full-time, some state agencies are remote, some are in person. I don't know the State Department of Education's policy, but eventually we'll be going back to that 60-day investigatory timeline. If it's a due process hearing, that is under a separate set of timelines. If a family files a due process hearing complaint with the State Department of Education, the hearing officer has to issue a decision within approximately 75 days after the complaint has been filed. There's a resolution period of 30 days where the parties are supposed to resolve the case, if at all possible. And then the hearing officer has up to 45 days to hear the case and issue a decision. That 45 days is often extended by agreement by the parties because there are scheduling difficulties, or we had storms last summer that knocked out power in part of the state, or sometimes there are vacation schedules over the summer. So that's what's supposed to happen, but often that 45 days is extended by agreement. And the hearing officer controls that, not the parents or their attorney or the school district or their attorney.
Attorney Berliner, I believe there's a form online for a formal complaint, correct?
That is correct, ct.gov, special education. And actually the CRP booklet has, as one of the appendices, the actual complaint form, if you want to use the form.
And Ali, that's something that you could help a family with, correct? You could help the family understand how to complete the form correctly and help them understand the timelines and who to submit the form to.
Yes, it's not a legal channel, so certainly I can facilitate that with family and guide them along the process, yes.
The policy on the CRP, it's a step-by-step direction. They have questions and answers, definitions. I might add there's a 1-year statute of limitation. There's only a 1-year look back period, so they're not going to go back 5 years with the investigation. So it's a user-friendly document.
And Ali, there was a question here again posed before tonight. It says, is that true? Does a reading specialist not work with a student with a learning disability? Reading comprehension in this issue is the issue.
Okay, so the question is about, does a reading specialist not work with a student? A reading with a learning disability, reading specialist can work with a student that has a learning disability if the student's needs were aligned to what the specialist is specializing in. In other words, if the specialist has training and authentic training and experience in, let's say, an approach such as Orton Gillingham approach, then the reading specialist is certainly appropriate to work with your student. However, if the reading specialist, let's say, is from your school district and your child needs an Orton Gillingham approach and the reading specialist does not have any kind of experience or specialty, Orton Gillingham is a very specialized, very unique program that requires, and I emphasize the word requires, a specialist in this particular area or program to be able to implement it. And so the long and short of the answer is yes, a reading specialist can work with your child if that person is qualified.
And I would add, should work with the child because they're qualified and not delegate that to somebody else. The Orton Gillingham practitioners talk about, in order to deliver the Orton Gillingham program, you have to be at the associate's level or higher. A lot of teachers, well-intentioned, I might add, only go to the introductory portion of Orton Gillingham or Wilson, and they don't pursue the higher level training, and for a lot of reasons. I'm not being judgmental, but in order to deliver the program with fidelity, you have to be at that mid-level, which is the associate's level, or the highest level, the fellow. And that's not me speaking, that's the practitioners of Orton Gillingham that talk about that.
Just to add to that, as parents, you have the right to question the certification, the background and experience of the person that's working with your child. You may not want to do that at a PPT, but certainly you have the right to do that. And with that information being informed, you would know if this particular reading specialist has that level that Attorney Berliner is talking about. But it is, a lot of districts will say to you, yeah, they're trained. Well, what is meant by being trained? Is it a 1 hour training? Is it a 1 day training? Or is it a fellow training? Or that mid-level training that you were talking about. So you really need to know the profile and the experience of who's working with your child.
I would add that to related services in general. It's important to know who is working with your child and what level of education that individual has to in all the related services, whether it's OT, PT, speech and behavior, because there are different accreditations given and different levels of expertise. And depending upon your child might require a specific, for example, speech, it might be prompt speech, and a certain level of training certification for prompt speech. But not every speech pathologist has that discrete skill in. So it isn't just reading that you have to maybe pay attention to, not only the related service and the related service hours or minutes, but also who's delivering that related service can be important as well.
Excellent point, because a lot of times parents will be told, well, the teacher is certified, or the person has the proper qualifications either from the Department of Public Health or the Department of Education, but that doesn't mean they're qualified. They may be certified, doesn't mean they're qualified. You want to make sure that both, especially if your child needs a unique form, not a generic form of a related service. One question just reminded me, we have some out-of-state visitors in our webinar, and everything that we're talking about is confined to the state of Connecticut. The question was, does the interim guidance I had mentioned apply to New York City? The answer is no. Each state and sometimes each county or each city municipality has their own policies depending on how the state government is set up. In Connecticut, we just have the State Department of Education and the local districts. So if the school districts have a specific mandate or a policy, they'll follow it. Otherwise, they'll use their own discretion. We also have,
what has been difficult for parents during this year is that districts have been strategizing differently depending upon their district, the composition of their district. So some districts, such as my own, my children have received in-person services for the majority of the year, compared to neighboring districts who did not offer in-person until fairly recently. So it's also been very difficult for parents to sit side by side with a parent in a neighboring town that has just had a very different experience during this period of COVID. And that has also caused a great deal of stress and anxiety for parents, even within just a small geographic area such as Lower Fairfield County, let alone the whole state. So it is important for parents to be aware of what their district strategies and approaches are, and to really understand their district. It does not always help to understand the neighboring district, particularly during this time of COVID. It has been different.
Yeah, we have 169 towns in Connecticut, and I think there's a little over 200 school districts in Connecticut, in a state the size of a postage stamp, and there's very little predictability when you move from one town to the next town. So it's very, very important to understand on the local level what's going on, as well as the mandates or the guidance that's coming from the state. It's all public. You just have to know how to navigate it. Google or the state website, you'll be able to get most of this information easily. It's available, just knowing how to navigate the websites. We had a question: how do you get a school to pay for the tuition and transportation? If this is a request for an out-of-district placement, usually at a PPT meeting, you make that request for an out-of-district placement. If that request is denied, then you make a corresponding request to be reimbursed for the tuition and transportation. As for me, as an attorney, this is not legal advice, but typically what I do is file a request for a due process hearing following a PPT meeting, and try to negotiate a settlement, if at all possible, on the tuition and transportation. But I have done this because all the facts and the law supports my client's position. I don't do this precipitously. So it's a good question, but we need to have a little more detail.
So there was another question here that's just been posed during our conversation. Who has final say on retaining a student, and what standards are used to allow for it? What should parents do if they want to retain the student, but the principal does not?
I have this question asked a lot because districts are very reticent in retaining students, especially if they are in special education. And there's various reasons for that. Firstly, school administrators and school staff will point to the evidence. There is evidence in both ways. There's evidence for retaining students and there's evidence against retaining students. But at a meeting, it's usually they only indicate, why they should not retain it and cite that evidence. The idea that for special education students, it's more difficult for the district to agree to retaining is because they will use the argument, so to speak, that an IEP is individualized, it's unique to your child. So no matter what level your child is working on, he or she will get the support and services at their own level. So if they're going into first grade and they're not quite there yet, they should still go into first grade, and the IEP will support below grade level work and try to close those gaps so that your child will certainly, close those gaps and reach grade level. There's different arguments about it, but to be honest, my understanding is that the school has the final say. I don't think that the parents, even though it's your child and you feel you know the child the best, the school district, and it's usually not even a PPT decision, but the school district, the board, and the superintendent make that final decision. I have had families actually meet with superintendents, and those one-on-one meetings I feel strongly that they can be very, very effective because the superintendent doesn't know your situation. You may have a child that not only is academically below, so developmentally lagging, but emotionally and socially, which to me is just as important, in fact, more important in many cases. So if you are denied retention, and if that's what you are seeking, I would go higher than the school meeting and go to higher administration, including the superintendent. That would be my suggestion.
And I concur, and I might add, I don't know if Jane has different experience, because often it's at the early grades that we're talking about retention, that I'm told it's not a PPT decision. So they shut down the discussion. So as Ali points out, there are studies that go in both directions, the positives and the detriments to retention. From my practical point of view, you're sort of having your child sit through a bad movie for the second time and expecting it to get better. So if you're asking for retention, it's not repeating the same grade and the same program. What's going to be different to boost the progress that wasn't obtained in the first year? And as Ali pointed, it really doesn't matter what grade you are because the IEP is individualized. So where's the robust IEP? Where's the meaningful progress? And less important is which grade. But these are legitimate concerns, and I do agree. The meeting with central office outside, above the building level decision is an excellent suggestion.
Yeah, because it can be multifaceted as to why a parent might wish to retain a child back. And it's important to be clear to what your reasons are and make sure that they're not just based upon an emotional impulse you have, but really based upon where your child is functioning and where they should be functional, where you would have expected them to function at the, perform at this point too. Sometimes we are driven as parents by emotion, which is really hard to tease out from actually what we see in front of us. So it is good to escalate it if you don't have success, but it is about, as we said at the very beginning, about communication and keeping channels of communication open and not burning any bridges, and to share your insight in your child, which you are the ones that have the most insight into who your child is and what you feel your child needs, to do it in a constructive way and to have a constructive conversation with the district.
Just on a personal level, my 38-year-old son still blames me for keeping him back in kindergarten. So true. So I mean, he said I could have had one extra year, and and out there. But it is, as Jane said, and all kidding aside, it's a very important decision because it can impact a student's life in the long run. So you really have to make sure that you've got legitimate reasons for retaining and go from there. So.
And I wouldn't, so of my 4 children, my youngest is probably the youngest in the entire school district. His birthday is December the 15th. A lot of students in his grade are 18 months older than him. He did receive RTI services. He did receive OT services and speech in his formative years. And other parents, funny enough, were putting pressure on me saying, you should hold him back. He's too young to progress. And I said, well, I do believe that with the right support, he will be okay. And flash forward, he's now a sophomore, and socially, he's definitely in the right grade. He would have probably socially found it more challenging to be with children that are slightly less mature than him. But it is a very complicated decision, and just trying not to be swayed by others when making that decision. As I said, the child, and go by your gut and your instinct, not necessarily what the trend is or what other people are doing with regard to that.
One item we didn't really get to was addressing pragmatic skills, anxiety, and social pragmatics. I know with the economic stimulus legislation that's been passed by Congress, there was a lot of money allocated to public education, special education, and carving out, funding for, I think they call it emotional learning. So I don't know where this money is between Washington and Hartford, and between Hartford and your local school districts, but you should be looking out for additional, what I'll call mental health services and supports for all children, not just children with IEPs, because we are dealing with a lot of anxiety. I mean, children who've been on hybrid or virtual learning may have lost social skills, the social connectiveness, how to read nonverbal communication, which is a lot easier in person than on a computer. So there should be more mental health supports, as I mentioned, coming into the districts probably as of July 1st. That's the beginning of our fiscal year. So I would be looking out in each district, because each district is going to do it differently, how that's going to be implemented, not only for regular ed, but also for special ed. And I don't know if Allie or Jane have anything addition to that.
The only addition I would say is with pragmatic and social skills, very often it's usually implemented, services are usually implemented either by the speech and language teacher, social worker, or co-treated. I see that once this skill is mastered, it's kind of wiped off the IEP and check it off, and that's it. I think that with socialization and pragmatic skills, we need to really focus on generalizing those skills. So generalization is really, I guess, maintained through repeated exposures and opportunities for the child to practice those skills. So it's important that not only do they master the skills on the IEP, but your child should be able to demonstrate it in a variety of settings throughout the school day, as well as community life and in-home life. So those are important considerations to be aware of.
Yeah, and the only thing I'd add to that is we are always aiming for the least restrictive environment. So I would ask the question, where are these skills being practiced? Are they being practiced with peers in the least restrictive environment? Because that is extremely important, particularly when you're talking about pragmatic, social, and communication skills with peers. It's just another piece to note and to request and to explore and find out.
We have one final question from an individual who says their child has been on remote learning because school was closed, and now the school districts wants the child to attend ESY, which is extended school years over the summer, in person. There's no remote learning option for the summer. And the question is, what happens if I don't send my child to ESY? Will the school district hold that against the parents when the child returns to school? This is a high school student. Any thoughts?
I think that this year is different if they've been remote all year because the parents are not comfortable with the COVID situation. I think that that is a very unique situation. It's for the parent to decide how comfortable they are with their child returning to in person. That's not a decision that somebody can make on their behalf because of the implications of COVID, depending upon where they are living. COVID numbers are different in different towns and different districts.
Just to add to that,
go ahead.
My experience with ESY is that, first of all, if the school has the responsibility to offer ESY if your child is eligible for it. So they are really meeting their end of responsibility by offering it, and they would want to document that on the IEP. It's always up to the parent or parents to either say yes or no to ESY. Again, my experience is there's nothing personal held against the parents for keeping your child back, and you can, not back, but from keeping your child home during the summer without attending ESY. But I would also encourage parents to document, if they decide not to send your child to ESY, the reasons. For example, you may want to say that your child needs more social interaction and needs to have a less structured time during the summer, or your child's anxiety is accelerated and you feel that more stress would be put on your child through an ESY program, whatever the situation is. But the school should not be in any way holding you responsible, or certainly look at you as neglectful parents for that. However, that being said, when he or she goes back to school in the fall, if there is regression, then you need to certainly address that. But the school will want to make sure that they are documenting the fact that they have offered ESY. So I can't blame the school for regression because they offered you the ESY, but just know that it may be documented at a fall PPT or so forth, with no regrets, but schools like to document, and they should, as well as parents should be documenting, as you should.
Well, with that, I'm just going to go to the very last question, and that is, how do we get a copy of the recording of this meeting? And that will lead to the conclusion. My daughter, Rachel, will provide a copy of the recording to anybody that's registered. So I want to thank her for all her behind-the-scenes work in setting up this webinar, all the technical aspects, including getting out the recording once we are concluded with the webinar. So I want to thank all that have remained with us throughout the evening, and most of you have. And Jane and I will be keeping a watchful eye on state and federal developments as we're moving into the end of the school year and going into the 21-22 school year. We've tried to address changes throughout the school year. It's a very fluid situation because of the COVID-19 pandemic, changing rules, wear a mask, don't wear a mask, in-person learning, hybrid learning. So we hope you found these webinars informative. Our next webinar, which will probably be our last one of this school year, will take place on June 9th, which is a Wednesday. And we will have Diane Ferber, who's a licensed marriage family therapist and a school psychologist. And we'll be discussing resetting the school experience going forward, how parents and students can start to prepare for the school year this summer and the transition to possibly a new learning environment in the fall. We will have additional webinars in the 21-22 school years on special education law and other issues with a roundtable and occasional guests like we've had in the past who specialize in a particular area, and certainly our guest next month who specializes in marriage and family therapy and as a school psychologist. We welcome your questions and suggestions for topics that are of interest to you. We try to plan around contemporary issues, suggestions. You can register for our webinars and upcoming events through our Facebook page, our website, the JCC website and Facebook page. And I believe we're posting these webinars on YouTube, as I understand it. So I want to thank both Jane for co-hosting tonight's webinar and the very valuable information that Allene Grafman has brought to tonight's webinar, given her vast experience, and I mean vast experience, on literally both sides of the table, being an educator and an administrator and being an advocate for the families that she cares deeply about, as I do, as Jane. So those are my concluding remarks. I hope Jane and Allie will add their concluding remarks to tonight's webinar.
I'd like to thank Larry and Rachel, and also his wife Debbie, for putting me in touch with Allie and for arranging tonight's session. It's been fantastic to meet you, Allie. You shared wonderful information and insight to our parents or anybody else that's been watching tonight. And Allie's contact information is in the chat, so please look at that. as well as you can get hold of myself or Lawrence through the contact information. And just check out our Facebook page, JumpStars. You can come and join me and some other parents and caregivers kayaking one evening, or as I said, taking a schooner sunset ride out on the Long Island Sounds. So take some time to enjoy and relax yourself this weekend if possible. It's been a very difficult time. Please think of yourselves and take that moment that you need as well. So thank you both, Larry and Ali.
Thank you, Jane, and thank you, Attorney Berliner. I ditto everything. I want to also thank Rachel. She's been extremely efficient in informing us and certainly keeping us up to date. And I also want to thank the audience because your questions were right on target. I learned so much from you by asking those questions because in my work, I need to know what's important to families. So by reviewing your questions and understanding what your priorities are, it helps me to be a better advocate. So tonight was a pleasure. I look forward to more opportunities, and thank you, everybody. Have a great summer. And remember, mom and dad and guardians, you are your child's best advocate, and don't let anybody else tell you differently.
Thank you and good night. Stay safe and healthy. Enjoy the long holiday weekend and the purpose of this holiday weekend as well.
Thank you. Bye-bye.